I'm very pleased to be able to say that we have two speakers this morning who know our President, Mr Callinan, incredibly well and know him not only through their involvement in the society during his tenure as our President, but also know him for his time prior to his service as the President of the Society in a variety of different roles which he has played in service to the nation in public life. I'm going to invite the Honourable Amanda Stoker and Alister Henskens SC MP to speak in a moment. Alister is going to go first and he's going to speak about Mr Callinan's time before his appointment to the High Court. And Amanda is then going to follow with the second half of the story of his lifetime of service. I'm not going to speak for any longer because we have limited time, but I'd like to thank them both for agreeing to do this, and thank you all for participating in this morning tea.
Well, thank you, Xavier, and of course I could give a much more expansive talk on Ian Callinan, the barrister, but we are being strictly held to time and I don't want to detract from our next speaker. To talk about Ian Callinan without talking about his love of literature, cricket, antiques, paintings and his family is to give a very myopic impression of Ian because they are all incredibly important parts of his life, and I note that Wendy Callinan is here today. I first saw Ian Callinan in 1985 as a law student in the public gallery of the old Banco Court when he was prosecuting Lionel Murphy in the first of the Murphy trials. Now, at that time, Ian had already had a very substantial practice which was growing. He had been president of the Queensland Bar Association and the Australian Bar Association. He had prosecuted the first bottom of the harbour tax case and also been counsel in the Mungenberry dispute, which with the dollar sweet case was one of the two leading industrial cases of its time and a very significant piece of jurisprudence. The newspapers had reported Ian Callinan as being a ferocious cross-examiner. And so when I saw him appear in court, very softly spoken, it was not a presentation which actually matched what had been reported in the media of him. Indeed, many of you will know that Ian is a particularly softly spoken person generally, only to raise his voice in cross-examination when there was some evidence of evidence which didn't accord with the truth. After the Murphy trial was an incredibly charged atmosphere. It was, of course, absolutely extraordinary to be prosecuting a sitting High Court judge for perversion of the course of justice. Stephen Charles, many of you will remember Stephen Charles in a presentation to the Samuel Griffith Society some years ago, who was counsel assisting in the parliamentary inquiry into Murphy's conduct, noted that a number of the grounds of misbehaviour which the inquiry had identified with regard to Lionel Murphy concerned the second Murphy trial, where rather than give evidence and be cross-examined by Ian, because Ian had been so effective in that first trial in his cross-examination of the judge, Lionel Murphy gave an unsworn statement from the dock some referred to as Coward's Corner. Charles and the inquiry had recognised that there were a number of aspects of his unsworn statement of the doct which misled the jury and constituted, in their opinion, at least a prima facie case of misconduct. Following that period of the Murphy trials, Callinan QC then represented the Queensland Government in the Fitzgerald inquiry. He was taking instructions from Mike Ahern, not from Bjorky-Peterson. He appeared in a number of leading commercial cases more frequently in Sydney, takeover cases, foreign currency loan cases, and so on. And that led to my first professional engagement with Ian in 1990, when as a junior solicitor at Allens, we instructed him in a sub judice contempt case for Channel 9, which was heard in the New South Wales Court of Appeal at first instance. Now, the interesting thing about that case is that it's probably the only time I've ever seen Ian nervous, and I think that was a function of appearing before Murray Gleeson, who was by then a friend, and also in front of Michael Kirby, who he had cross-examined as a character witness for Murphy in the Murphy trial some years earlier. The following year in 1991, I came to spend 12 weeks in Brisbane with Ian, where I instructed him in a long defamation case for Channel 9 against Sir Leslie Teese. Much to the disappointment of Wendy Callinan, the jury found that Teese had bribed Bjorky-Peterson on a large scale and on many occasions. And we were successful in proving, I think, 3 or 4 imputations were true as the defendant. After that case, Ian then appeared in many cases, many famous cases, the Skase extradition from Majorca, the defence of Alan Bond over that painting, gas arbitrations in South Australia. He represented Greg Chappell. He appeared for the magazines who were being sued by Andrew Eddinghausen in a defamation case. When a witness against Tom Hughes, when a witness was prevaricating about whether the photograph showed Andrew Eddinghausen's private parts, Tom Hughes gave the famous cross-examination line, "It's not a duck, is it?" As only Tom Hughes could do. By 1997, just prior to Ian being appointed to the High Court, I was privileged to be led by him in a 5-day appeal in the New South Wales Court of Appeal. Can I just wrap up by making a few observations about being privileged enough to work with Ian? Ian was and is always absolutely courteous, respectful, polite in every interaction you have with him. At the time, it was very common for senior counsel to be somewhat hard to manage, but Ian was not one of those senior counsel. In fact, the greater risk being in court with Ian was not being admonished by a silk turn, but rather having to control your laughter while he was joking, sometimes doing impersonations of Tom Hughes and others, saying, "Come on, old son, where's that document? Come on," and so on. So it was a delight to work with Ian. He always had a genuine interest in the people that he worked with. We were unaware at that stage that possibly that was all a precursor to appearing in a play or a novel. But he was a great mentor, incredibly generous with his time, and his contribution to Australian life has truly been magnificent. Thank you.
Good morning. The Samuel Griffith Society has been so blessed to have the wise leadership of Ian Callinan as our chairman for so long. As a nation, we have benefited from his mastery of advocacy at the bar, applied later as reasoning from the bench. And like many of you, I have had the immense privilege of calling the judge and his formidable wife, Wendy, friends. And perhaps differently from many of you, I've also had the joy of looking up to and learning from him as an associate early in my career. The judge has continued to, by his gentle advice and occasional correction, continued to develop me as a lawyer and as an advocate in the many years since. I believe some others of his associates are also attending parts of the conference this weekend, and we've got Pat McCafferty of King's Counsel here too. For that opportunity, I'm enormously grateful. I don't think I'd be here and have done the things that I've had the opportunity to do if it weren't for his influence. It's something that he's done generously in different ways for all of the judge's associates. To put that gratitude into context, I'm a plumber's daughter. My mum and dad, though they encouraged academic pursuits, didn't really understand what was involved in them or really understand what was involved in going to university. Mum would often say when it seemed like I was spending too much time studying or stressing that it would be better perhaps if I stopped doing that and drove a concrete truck instead. Now, I don't know if you've seen the price of concrete, but going into the concrete business wasn't, as it turns out, the worst financial advice. But the point of the story is to say that my very loving family knew basically nothing about the law, even if they were pleased that I'd entered the profession. So whenever I had difficult career decisions to make, or ethical or other questions to ponder, I was so pleased that I could always turn to the judge. He would always be generous with fatherly advice, and in doing so, he made a profession that can occasionally seem dynastic and cliquey a little more open to a girl from a background that's more V8 supercars than galleries and concertos. Now, perhaps that's a reflection of his own humble upbringing, the fact that he too was the first in his family to go to university or join a profession. Perhaps it reflects the genuineness of his interest in others or his ability to connect over shared interests across the generations. You will know that in his time he's championed the arts, written no less than 13 works of fiction, 4 of them have been on the stage. He's been a devoted husband and a father of 2. Mrs. Wendy Callinan is herself formidable, accomplished on the land. She's whip-smart and clear in her convictions, and it is absolutely no wonder that the 2 of them have been such an effective partnership. Judge, in many ways, your achievements are also hers. But Wendy, I must apologise, hopefully one last time, for aiding and abetting so much the judge's penchant for art shopping. I promise you he transmitted the habit. It is, however, in his work in defending our Constitution, the very motto of this society, that the judge has served our nation best. In the High Court, the judge exercised great restraint in his decision-making. Now, there are some judges who are unable to resist the temptation to dip into matters of politics, and in doing so expand the remit of the judicial branch of government beyond the matters for which it was designed by our founding fathers. But in bringing his own kind of originalist approach to the task of constitutional and statutory interpretation, he did so much more than merely avoid fashion. He deliberately declined repeated invitations to expand the remit of the court into matters properly for parliaments or properly for the Australian people at a referendum. And he did so as a mark of respect for our institutions and for the good sense of the ordinary man and woman. In doing so, he played an important part in seeking to protect the judiciary as a whole from the loss of public confidence that comes when activist judges dabble in politics. That risk is serious, of course, because our judges don't face the same mechanisms for accountability that those who seek political office face. When some politician gets it wrong, their constituents have the opportunity to tell them just how badly they got it at the next election, and not so for our judges. But there's a deep morality to the preference the judge expressed for originalist and textualist approaches, though it has never been in his character to preach at others. That stands in contrast to the many who dominate in our law schools, who prefer to think of their law as a living tree, growing and adapting to the cultural, social and technological fads around us, even if that requires the implication of words and concepts that are simply not there. But what could be more moral than the notion that an ordinary Australian should be able to read and understand the laws by which they are expected to abide? That one's obligations should be plain and their rights clear, even if that requires amendments to legislation by parliaments who need to themselves better pitch for clarity. What characterises His Honour's contribution, I'd suggest public and personal, is an integrity of character. It's embodied in his restraint when faced with those invitations to expand the judicial branch's remit, or invitations to centralise the legislative power of the Commonwealth at the expense of the states. Perhaps that aspect is best illustrated by His Honour's decision in the work choices case. That legislation passed by the Howard government represented significant economic reform, but it was in its own way radical. It required an expansive understanding of the scope of the corporation's power, one which could only have expanded the remit of the Commonwealth at the expense of the states permanently if upheld. True to his duty to the Constitution and to the federal balance, His Honour was prepared to reject it. It was inconvenient for the government, but it was the right thing to do. And I'd suggest that it's a judgment that has aged well. More than one former parliamentary colleague of mine has remarked over the years that much of the electoral difficulty caused by work choices as a policy proposition could have been avoided were our party more faithful to federalism and more willing to live out the approach of constitutional restraint for which we have traditionally stood. That intellectual integrity was demonstrated by His Honour, and it has served our nation well. In Lenegay Meats and in other cases, as well as extrajudicially, His Honour was prepared to robustly defend the right to privacy, perhaps reflecting his deep expertise from the bar in the law of defamation. In decisions like Coleman and Power, he was prepared to articulate a broad definition of Australians' right to speak freely. In Chang and Laidley Shire Council, His Honour was prepared to stand for the importance of private property rights in the face of local and state governments applying layers of planning and other regulation with the effect of stripping value from real property. He observed the unfairness of the notion that one has a right against the Commonwealth to the acquisition of property only on just terms, but no such right as against the states. And in many a criminal appeal, His Honour was prepared to robustly stand for the presumption of innocence, the protection of the rights of the individual against the big state, even where to do so meant finding for unattractive litigants or enduring some teasing from his associates about being a bleeding heart. I could, of course, touch on many more decisions which have helped to shape modern Australia for the better. Your judicial restraint may not be fashionable, Judge, but given that some of the trends celebrated in modern law schools are the legal equivalent of leg warmers or fluoro happy pants, certain to age poorly with the benefit of hindsight, that is perhaps for the best. They are the smart but practical outfit that, when more widely applied, will clothe each person in our democracy in understanding and build trust in our institutions. He has discharged the heavy burden of public office with integrity, with generosity of spirit and with good humour. And so it's perhaps on the last of these qualities with which I will conclude. You may know that His Honour was for several years the chairman of ADFA, the Australian Defence Force Academy. And while holding that role, he travelled to China, but in his capacity as a judge. With his usual modesty, the judge was surprised to find himself on the receiving end of a large security detail, complete with doctrinaire minders, with red carpets, military parades and near continuous displays of technology and military enthusiasm. He reflected that it all seemed a little over the top, given the purpose of the trip, which was focused on the law and jurisprudence. He remarked with good humour that despite some frustration with the constraints that came with all of this fuss, a penny dropped for him in a conversation as his trip came to a close. Language difficulties being what they are, his position as chairman of the Australian Defence Force Academy had been misunderstood in the process of translation as Commander-in-Chief of the Armed Forces of Australia. With his usual good manners, he didn't point out the error. Judge, I hope this morning tea is just the start of our own parade in honour of your considerable service, though ours is presented with a more accurate appreciation of your contribution than that which you received whilst travelling. Will you please join with expressing your thanks for his honour service of our society and of our nation, with an applause that seeks to match the enthusiasm displayed by a CCP military parade.
Alister and Amanda, thank you very, very much, even though a great deal of it was excessive. For a lot of the time, I thought you were talking about somebody else, but I'm grateful. Look, I won't take up very much time. This was completely unexpected. I would like to say just a few things, though. I'd like to thank my wife, Wendy, for all the support I've had from her. About 60 years ago, I was a junior partner in a small legal firm, and I said to Wendy, I think I'd like to have a shot at the bar. And she said, oh yes, Wendy doesn't come from a legal family. And I said, you know, it's risky. It can be very risky. I could stay in this position and probably improve things there. And she said, oh no, give it a go. And I've had unerring and constant support from her for all of the 60 years that I have been a barrister and a judge, and have had the good fortune to have a subsequent post-judicial legal career of a limited kind. There are only a few other things I'd like to say. Alister talked about a number of cases. We had a lot of fun together, Alister, over those years. Amanda was my last associate and one of the best. There's no doubt about that, and I watch Amanda's progress both politically and legally with a great deal of pleasure. Could I just say this? I've had a very long and lucky career. Good parents, good wife, good family, good colleagues. If I can borrow from Churchill, Churchill said that, you know, Churchill liked to drink. It's well known that he liked to drink, and he said, don't you tell me about alcohol. He said, I've got more out of alcohol than alcohol's ever got out of me. Well, all I can say is that I've got more out of my colleagues, my family, my friends, my opponents in court, Tom Hughes, for example, who's an old friend and who will be 100, I think, next month. I've got a great deal more out of them in terms of friendship, support and amusement than I've ever given to them, or indeed to anybody else. But I'm I'm overwhelmed by the tribute you've paid me. Thank you very much.